Hi there, this is Thomas Leonard Ross, KC, in the Glasgow Advocate Talks series. It was back in November when the judgment of the United Kingdom Supreme Court was issued, and I gave a brief overview of the decision then, and I promised to come back on and give a bit more detail regarding the subject matter. It never quite got round to it. As it happens, I'm doing this talk on the 5th of February, and on the 4th of February, I did a talk for the Scottish Medical Legal Society on the subject. And as a result, it occurred to me that it might be a good opportunity, having put some thoughts together, to come on and share them with you. I think I'll probably do it in two parts. There were a series of cases which the Supreme Court considered and formed part of their observations. That's probably the second part. The first part was a series of cases which gave an illustration of the way in which the Scottish courts were dealing with the rape shield provisions, because, as I said last time, in the Supreme Court judgment, Lord Reid said, and I quote, "It follows that the Scottish courts are under a duty to modify their current approach so as to ensure that decisions on admissibility are in conformity with the Convention by virtue of Section 6, subsection 1 of the Human Rights Act." So when he's talking about the approach being modified, he's clearly giving an indication that he thinks there's something wrong with the way that these decisions are currently being taken. Now, I've been on record for a number of years now in saying that I thought there was something wrong with the way in which these decisions were being taken, and in particular they were being taken without due regard to the accused's convention right to a fair trial. I accept there's a balance to be struck, and I'm firmly against aggressive, unnecessary, irrelevant questioning designed simply to upset the complainer. I think everybody agrees with that. But there's a balance to be struck, because sometimes difficult questions do have to be asked of the complainer if a fair trial is to be secured for the accused, and that's the difficult territory. But so rather than repeat my thoughts, which are already pretty well known, the purpose of this talk is really just to give some indications of real life cases which are reported actually. So you can check them yourself and consider whether you agree with my description of them. And I do that under a number of headings, simply headings of cases which have repeatedly arisen, and illustrate the problems that the courts have had to wrestle with, and the way in which they have ultimately decided those questions, and generally in favour of not allowing the questioning which some people might think completely relevant questioning. The first issue I deal with is false reports. This is a subject that I have never really understood. I've never understood the Scottish Court's approach to that, because it's always seemed to me that the example I give is this: that if I made a claim for invalidity benefit on the basis of something which was really impossible to diagnose, for example, if I said that I had a bad back and claimed benefit and was granted financial benefits for that, and then was captured telling my pals in the pub that I never had a bad back in the first place, and that I had conned the Department of Work and Pensions out of a couple of £100 a week. If that was reported back to them and the benefit claim was stopped, and then I went back 3 or 4 years later and claimed benefits on the basis that I had a bad back, I don't think many people would think it was illegitimate for the benefits agency to take account of the fact that I'd previously made a false claim which I admitted was false. I mean, anybody would think that they should be allowed to take that into account in assessing whether I was telling the truth. But surprisingly, in Scotland, you're not allowed to, the jury are not generally permitted to hear about false claims which the complainer has previously made in determining whether somebody should go to prison, which is ultimately the result if somebody is convicted of serious sex offences. And by way of an example, I give the example of CJM against Her Majesty's Advocate, which was in 2013. M was charged with repeatedly carrying out indecent assaults upon a child when she was aged between 6 and 10. The complainer had made no complaint about this until about 2008. The significance of that will become obvious. M sought permission from the court to read evidence that he had in 2006, that she had in 2006, when she was 17, fabricated an allegation of having been previously sexually abducted and made to perform sexual acts. The trial judge refused permission for such questioning, and on conviction he appealed. In the appeal, more information of the false allegation was given. It was said that in September 2006, the complainer had made an allegation that she and another female friend had been abducted by a male in a car and driven to a wooded area. There, forceful sexual demands were made, including a demand that they perform sexual acts on each other. She and another girl had turned up at the door of a stranger in the country and made these allegations, whereupon the stranger had driven them home and was so concerned about what the stranger had been told, he or she contacted the police the following day to follow up, and was told that no report had been made to the police. But the police, having been advised of it, clearly looked into it, managed to trace the girls. The other girl was traced and did not support the allegation, with the result that the complainer was interviewed on tape by police officers, and as it was put in a letter from the fiscal, readily admitted to having fabricated those aspects of her evidence relating to her allegation of abduction and the unsolicited nature of the sexual demands made by the male. That's my reading of the case. So she made a fairly detailed allegation to a stranger about specific sexual acts, and then when challenged by the police on tape, conceded that that had not happened. And when permission was refused by the trial judge and it got to the appeal court, one of the comments by the judge delivering the opinion of the court was, the problem which arises in this case is that there is no conviction for wasting police time. There was no prosecution, and even the reasons for that are not clear. Now that as an approach shows what an accused person is up against, because an accused person has absolutely no control whether the police charge somebody with wasting police time, or whether Crown Office in Edinburgh prosecute somebody for wasting police time. So yeah, it's difficult to understand how it's just that should be held against the accused. But it went on, and the opinion went on to say, first, the incident is not linked in time, circumstances or place to the charge in the libel. The complainer made a complaint at or about the time. This is in contrast to the allegations in charge 4, which involved the repeated sexual abuse of the complainer during the years 94 to 1996. The two matters appear to be quite separate in nature on this ground alone. The court considers the evidence of the 2006 incident ought to have been excluded as collateral at common law, so the appeal was refused. Now, the obvious difficulty with that statement is that although the abuse happened in 94 and 96, she didn't report the abuse, it would seem, until 2008. So there was a temporal link between the two events. It was said that in 2006 she had made this allegation about being taken into the country by a stranger, and in 2008 she'd made the allegation against the accused. So it seemed to me that using 1994 and 1996 as the relevant dates, in the sense that those were the dates when she said things had been done to her by the accused, on one view seems a bit unfair. But it's worse than that, because even when there is evidence that one of the complainers has persuaded another person to make false allegations, even that isn't allowed as evidence. And that's the case of RV against Her Majesty's Advocate in 2020. In that case, RV was charged with sexual assaults upon his son, who we'll call A, and upon his partner, who we'll call B, between 2012 and 2019. He sought permission to lead evidence that between September and December 2018, his partner B repeatedly induced and attempted to induce her sons, A and C, to make false allegations of sexual abuse against teaching staff at their school, and that an interlocutor of the 26th of March 2019 of the Sheriff of Ayr, following a proof at which referral grounds were established, confirmed the following facts: that A had repeatedly made false allegations against specified teaching staff, and in particular did so on 4 separate dates. So the suggestion that the complainer had persuaded her children, or attempted to persuade her children, to make false allegations against teaching staff wasn't just a kite which the accused was flying. It had actually gone before a sheriff in relation to children's proceedings, and having heard evidence, the sheriff found those grounds established. Different standard of proof, but was satisfied that it was proved that the complainer had done exactly that, had attempted to persuade her sons to make false sexual allegations against teaching staff, which is obviously could have extremely serious consequences for them. And worse than that, the sheriff refused that application, but he did grant an application on the basis that between June and August 2018, B, the partner, had attempted to induce the other son, C, to make false allegations of abuse against the accused. So the sheriff had actually heard discussion about that. The Crown seemed to accept it was reasonable for that to be raised. And so when the case went to the appeal court, maybe 80% of the application had been refused and was subject of the appeal, but 20% or 10% of it had actually been granted. So in a way, wasn't really part of the appeal process. But when it got to the appeal court, not only did the appeal court refuse the application to be allowed to lead evidence that one of the complainers, the partner, had been trying to persuade her sons to make false allegations. Not only was that refused, but the court went back and reviewed the sheriff's decision to admit the other part, namely that she'd been trying to persuade the other son to make false allegations against the accused, and back and reviewed it and refused that as well. So, he went into the appeal hearing maybe with a 10% success rate and in relation to the application, and come out with nothing. That the entire application, or at least those grounds of the application, were all refused. But the one that really shakes people up a bit when I talk about it is the case of S in 2021. S was charged with 7 charges, 2 of which related to the same complainer. The Crown instructed a psychologist to examine the complainer to support a vulnerable witness application, presumably with a view to perhaps seeking special measures in terms of the complainer giving evidence by commission, pre-recorded before the trial, or perhaps by a video link, something like that. And the report, which was provided by the psychologist, concluded that the complainer suffered from borderline personality disorder. including a diagnosis that she displays impulsive behaviour characterised by pathological lying. Reports were disclosed to the defence, and the accused S made an application seeking to lead evidence A, that X suffers from an objectively diagnosed medical condition, namely borderline personality disorder, which is a mental disorder. As a result of her condition, she displays impulsive behaviour characterised by pathological lying, and that during assessment by the psychologist on 20th January 19, she advised the psychologist that she is, in quotes, a pathological liar. And in the report, the psychologist concluded she freely admits to lying for attention, to cover her behaviour, for financial or other reasons, or other pathological lying, insofar as she has a habitation to lying at times for no obvious personal gain as a feature of her personality disorder. So those reports having been disclosed to the defence, they sought permission to lodge them. One of the complaints that the complainant had allegedly made, or apparently made, was that the accused had broken into her home, tied her to a bed and sexually assaulted her, and it said that when that was checked, the accused had been serving a sentence of imprisonment at the relevant time. And so basically the accused's position was, I have evidence which contradicts the factual position stated by the complainer, which supports the suggestion that she's lying about it, and in addition I have a diagnosis that she's a pathological liar from a medical professional. A application refused, not permitted to lead evidence, and the opinion of the court stated, evidence of character is generally inadmissible at common law. It would not be sufficient to show that the witness was simply a habitual liar. Jury don't get to know that. I went on to say that pathological was used by the psychologist not to refer to a consequence of the illness, but as a synonym for persistent or habitual. There was an absence of a clear diagnostic medical link between the condition and any tendency of the witness. So the evidence was inadmissible at common law. So even when you had evidence from a psychologist that the complainer was a pathological liar, when you were facing a trial, when the job of the jury was to consider whether that person was a credible and reliable witness, even in that situation, the practice of the Scottish court was not to admit the evidence. And the other category is in relation to things said by the complainer. That's as an example, the JW case in 2020. JW met the complainer on an online dating site and had been exchanging messages over a period of a few days before they met up in September 2018. He was charged with abduction and rape, both vaginal and anal rape, on the day of their first meeting and on the following day. He sought permission to lead evidence about the content of communications which had passed between the accused and the complainer by text in the days prior to meeting up, which included messages in which the complainer had said to the accused that she had a high sex drive, she had a preference for double penetration, and that she enjoyed anal sex. This material had been lifted from a statement that the complainer had given to the police, which had been disclosed to the defence, and he was denied permission to use that material, so the jury didn't get to hear it. That case actually features quite notoriously in the Supreme Court judgment, and I'm going to come back and look at the way Lord Reid reviewed the work of the Scottish judges in his opinion, or the opinion of the court which he delivered. So I'll come back to that one, but that's almost 20 minutes. Can I say I'm giving these examples? I'm not suggesting that any of the accused were innocent. I don't know whether they were innocent or not. It might be that even if all this material had been admitted, as I think it should have been, then the jury might still have convicted the accused. And obviously I haven't heard the complainers' position in relation to it. So that's the first cautionary point, that I'm not saying that anybody is innocent. What I'm saying is I'm concerned that they didn't get a fair trial when this material was withheld, and to some extent, looking at the Supreme Court's judgment, there's some support for suggesting that the most senior judges in the United Kingdom, so far as human rights matters are concerned, probably agree with me. The other point, which I don't know that I have made before, is this is a disaster for complainers, because we now have hundreds, if not 1,000, people who have been convicted of sexual offences maintaining that they're innocent and are able to say, well, material was excluded in my trial, and the Supreme Court has now said that the Scottish courts were not observing the rules properly. So even the guilty, even the people who are undoubtedly guilty, are now able to say that, use the Supreme Court decision as support for the idea that they were wrongly convicted. So it's not a happy situation, and we're now several months on, 3 months on nearly, and the current position of the Scottish Government seems to be it's up to the individual accused, many of whom are in jail, many of whom don't have two bob to rub together. It's up to them to access lawyers and sort it out, even if their appeals have already been refused. So that's I wanted just to come on, as I promised to do, and give some examples of really good illustrations of why people like me thought there was a problem, and presumably how the case ended up being reviewed by the UK Supreme Court in the first place. So that's it for today. Thank you very much. If you have any questions in relation to it, please just let me know. Thank you.